Hi everyone, Brad Wylynko and Mark Etherington. We're here to talk about the Environment Protection and Biodiversity Conservation Act review that is currently underway. First of all, let me apologize that we weren't able to do this in person for obvious reasons, but that's the least of our worries, I think, these days with some of this virus stuff going around. So what we thought we might do is just have a conversation between Mark and myself, review some of the issues that have arisen. And it's really just an opportunity to think about some of the issues that this review is posing for everybody to consider. And I think it's a great opportunity presented by this review, noticing that it's Graeme Samuel who's heading it up. This is the discussion paper that we'll be talking about, because they seem to really be tackling things at a fundamental level. So unlike many reviews of environmental legislation that have occurred over the years, whether state or federal, this review seems to be really asking some of the hard questions. So it's a great opportunity to talk about some of those hard questions. And I thought we might just start off with, Mark, what do you think, in your view, is some of the key hard questions that are being asked in this discussion paper?
Look, I think it's a really good opportunity here because it is really talking about a roots and branches review. This is not just a tinkering around the edges. I mean, what I found really interesting reading the paper was that there's a lot of references in here about potential changes, which does marry up with the Hawke review some 5 years ago. And possibly the fact that it's a Graeme Samuel review rather than an Alan Hawke review, it might be seen more in a legislative regulatory sense than rather than an environmental review. So I certainly think there's a great opportunity here to make some quantum changes in the way that the regulation works.
I think too, in addition, and maybe a reflection of why they picked Graeme Samuel to head this up, the timing seems right. There seems to be a certain degree of impatience, if you will, I think, across the board, is the sense I get, of not just industry or government, but environmental groups and so forth, the frustration, if you will, I guess, with the way the thing has been operating over the last couple of years.
Look, I think that's right. I think you'd be struggling to find a segment of the community who would be out there saying no changes at all, it's perfect.
No, that's right. And one of the big things that they've started with is asking the question whether the feds should actually be doing environmental reviews at all. So as you'll know, there's a range of matters that are dealt with in the Act. But one of the principal things, and one of the principal frustrations I think people have felt with this piece of legislation, has been the manner in which environmental reviews have occurred. And one of the things that they're talking about here is whether, in fact, the feds should be doing environmental reviews at all.
Look again, I mean, I think the discussion in here, and again, a similar discussion was made in the Hawke report as well, is quite valid. I mean, trying to take a step back and look at it in terms of, if the feds weren't doing a review, at least within the West Australian context where threatened species are very endemic and we have very few cross-border issues, what great value add does the federal regulation add? Because more often than not, it does seem that the assessment processes are purely duplicative, and query whether the current assessment bilateral process is working. The approval bilateral, which is proposed, may make a world of difference, but as it stands today, I'm not seeing a value add for the environment.
Well, I think it's not just whether it's working, but when you look at some of the situations that we've seen where evaluations are being done on very small parcels of land, far removed from any real Commonwealth connection, other than the fact that perhaps there's Carnaby cockatoo on the land, and you'd think, you really want the Commonwealth spending its time reviewing, say a 4-hectare development in the middle of, in WA? It doesn't make any sense.
Look, I think that's right. I mean, the paper has some interesting points about strategic assessment approaches, about bioregional planning, and also about policy making. And, there's a big question mark that if the Commonwealth resources were put more into those spaces, in padding out the guidelines, making them more context specific rather than to some degree the motherhood statements that they are at the moment, we actually may see better environmental outcomes come through. And I think if the Commonwealth did that, that would flow through into the state assessment in any event.
But how do you do that with the Constitution? I mean, how do you, the basic problem that seems to be is that they've tried to respond to the constitutional position of the feds by saying, okay, we're going to focus on threatened species, for example. So once you've taken that focus, how do you then shift it from saying, okay, well, if it's threatened species, cockatoos, wherever they're found, whatever project might have a significant impact on this matter of national significance, the feds should be involved. How do you get away from that?
Well, I think I don't see that there's too much of a federal-state issue, provided they're not performing the same role, which ostensibly they are at the moment. And again, for many of the threatened species in Western Australia, it's difficult to see there being Commonwealth significance that's over and above the state significance. So again, we are essentially assessing the same things twice. But there could well be a role for the Commonwealth, particularly in standardising regulation on a national scale by saying, look, we're going to focus on these black cockatoos.
That's what it talks about here. Yeah, exactly.
Legislated, WA based, but we're actually going to really beef up the recovery plans. We're actually going to do some regional work about which patches should be kept and which patches are not as important. And again, that would provide guidance both for the state assessment and possibly be a better allocation of scarce resources, but I dare say it would get better community engagement as well on this.
The problem you're going to have, though, is setting those standards, isn't it? I mean, that's what it talks about here, amending the Act to move towards a national standard setting approach. But national standard setting isn't easy.
No, I mean, and it requires on-the-ground work.
In lots of areas, we see this all the time, right?
Yes, I think that's exactly right. What does one mean by national standard setting? And at least to my mind, it's got to be more than just we've got standards that apply across the country, across species, and they're of a similar level of robustness or the like. I think what it's actually got to mean, there's got to be some research, some money putting into providing that background data, which is not.
Well, and some coordination with the states.
Indeed.
Right? I mean, that's like they reference here through the National Environment Protection Council, air quality standards, waste, site contamination standards. Those are all good examples, but those were not arrived at easily or quickly.
No.
You know what I mean? And they continue to evolve. And so, yes, having broad national environmental standards as a basis for your review is probably the way to go, as long as they beef up the process to do it.
Indeed. I mean, there are certainly some good examples in the environmental sphere of national standards, and the Contaminated Sites Assessment Guidelines, which apply through the NEPM, are a clear example of that. That is a very beefy document setting out methodologies and approaches that can be applied across Australia in different contexts. And if that's the sort of approach they're taken, then I could see value in it.
Yeah. So maybe if we moved away from the bilaterals, in a sense, well, maybe you still need some kind of a bilateral arrangement, but maybe you need to combine the assessment bilaterals and the approval bilaterals, because otherwise it just ends up with duplication, it seems, anyway.
Yes.
And then layer in a standard setting exercise so you can get away from the feds being involved in the small stuff and focus really on, I don't know, the offshore projects that cross state boundaries. I don't know. You still have to have that national significance tie-in, I guess.
On that theme, there is another interesting comment which talks about, is there scope for effectively self-regulation in the sense of, here are the guidelines, if I comply, I don't need approvals. Great in theory, obviously difficult to be done, but if we actually do see strategic assessments being run by the Commonwealth, which provide a detailed framework of what is deemed acceptable activity, then I think that can work. But without the feds moving fully into that space and providing that background regulation, I just don't see how it's...
Well, that's a thought, though. That's a thought, isn't it? I mean, a strategic assessment role.
Yes.
Rather than a project assessment role. So the federal role is just strategic assessment, and then that's setting the framework within a set of standards for the feds to be, or for the states to then be able to come in, states, territories to be able to come in. That would kind of make sense, wouldn't it? Yeah. Some of the other issues that are in here, I mean, it talks about that the legislation is repetitive, complex, and unclear. And as you can see here, it's obviously voluminous as well. That's nothing new, is it?
Certainly nothing new. Almost a direct lift from the Hawke Review commentary. So clearly after the last review, the tinkering to the Act did nothing to address that, possibly made it worse.
Yeah, possibly made it worse. That's right. And then they talk about the Act as an example of traditional rules-based regulatory model, and it's important to question if the current process-based regulatory approach is delivering the desired environmental outcomes in a timely or efficient way. And this gets back to your point about could be modified to enable self-regulation or co-regulation. I'm not quite sure what co-regulation means, where basic conditions are met. So how would you actually try to move away from rules-based regulatory model to something else?
Look, I think that would be very difficult, and I'm not sure that you would get the community buy-in on that. The community will be looking for certain standards and to judge projects by, whether they're acceptable or not, particularly in light of the obligations that Australia has under international conventions to not have a rules-based. I'm not sure we would then meet our treaty obligations. So I think that becomes a very difficult area, and I wonder if that might be a bridge too far for at least this review.
Well, another interesting point they make here is they suggest there could be a general duty, similar to occupational health and safety duties. And that makes me think of the duty that's brought in Victoria. And we're waiting to see how that's going to work out, a general duty to not cause environmental harm, to protect the environment. It would be interesting. That's might be a bridge too far. I'm not sure with Commonwealth legislation to look at a general duty.
Yes, I think you're right. It's we'll wait and see in the Victorian model. No one else has picked that up from a state-based regulatory approach yet, and we'll see how that works. But again, whereas it clearly works in an health and safety perspective, where ostensibly the employees can litigate, unless we're going to have rights for the environment.
Yeah, that's right. Tree standing,
which can be litigated. I've got some doubts in that area.
Yeah, how effective that's actually. Well, like you said, we'll see with Victoria, I suppose. The other thing that they're suggesting here is that there could be a separate statutory authority. They'd be the responsible decision maker rather than the minister, I guess. Now, that's an interesting idea, but I think there's a lot of, you can see the upside in terms of trying to depoliticize it, but on the other hand, people worry that then you're handing the power over to bureaucrats.
Yes, and most of these decisions are made by the minister's delegates, at least through the process, certainly not all the actual approvals themselves. But again, the minister is relying ostensibly on a brief in most cases, so I'm not
sure it would be that much different at the end of the day. The minister relies on the advice that he or she gets.
We'd like to believe
from the experts within the department anyway, right? So they are independent. The difference might be, certainly in WA here, we've got the EPA to give at least recommendations, independent recommendations, and go through a public process. The feds just don't have that, but there's no sort of independent group bringing an eye to bear.
Yes, there is that interesting comment about what was a co-regulation, I think is the term used. Again, in the Hawke Review, there is a passing, almost throwaway approach, which presumably was trying to facilitate an approvals bilateral arrangement as such, where they were suggesting that the Commonwealth officers could actually sit on a joint development assessment panel with state members. If we saw the feds move into that strategic space, that national policy setting space, I could see that working particularly well, because it would mean that someone sitting on the assessment panel has full working knowledge of those aspects. But
sorry, do you mean like a federal person, a federal rep sitting in on EPA?
Yes.
Interesting.
Merging that, so
right.
A bit like development assessment panels with people from different disciplines.
Yeah.
Look, who knows? I suspect that that's probably, from a legislative drafting perspective, maybe more difficult. So I'm not sure that idea is going.
Well, not if the Commonwealth had some group of people that it could turn to, some group of experts that it could turn to, and it could say, okay, well, in dealing with this particular situation in WA, here's the expert over here. Let's pull them in and get them involved in that assessment exercise. And then we can have comfort that when that comes back through to the minister or whomever to make a final decision, we don't have to review it all over again, which is what tends to happen now.
Yes, I mean, look, there is a potentially really interesting scenario that does extrapolate out of that, and that is actually if you end up getting one national body that deals with both state and federal, and then depending on which state it is the composition of this panel. Whether the states will buy into that arrangement or not, but that may well be where Graeme Samuel is ultimately thinking in terms of consistency on a national basis, because certainly the argument there would be the quality or the approach to decision making will be consistent across state and federal jurisdictions.
One of the last things to talk about is just there's mention in here about offsets, and offsets has been a big issue with the Commonwealth coming in and requiring offsets, often quite a bit more than what a state has been requesting. I'm not sure quite what they're suggesting here. They just seem to sort of review it and say, increasing role for offsets and also things like tradable units for biodiversity conservation. I don't know. Do you think, Mark, there's anything really to be done for the feds in terms of offsets? I mean, some of the ratios that they've used have been very high.
Going back to Fiona Stanley, I think that was 10-1, and that's at least a decade ago, or not, if not more. Again, I don't know that there's far to go with offsets without getting into a landscape scale strategic assessment, cumulative impacts, where the offsets can actually be targeted on a regional basis and say this is how the benefit is plugging in. So yes, we're prepared. Otherwise, we're perpetuating small cuts and benefits that don't necessarily come together, particularly when sometimes it's done by the feds and sometimes it's done by the states. And then query, if we're talking about buying land, it goes to DBCA and question about how they're managing the land and what they're actually doing with it. So, look, I think offsets is a question that needs to be raised and there needs to be a discussion about it. But without broader fundamental changes to the Act, I'm not sure we're going to get clear resolution on that issue.
Submission deadline for this, for comments on this paper was extended to about, I believe it's mid-April, April 15th or April?
Yes, that sounds right.
I think that's about right, April 15th. So you've got a bit of time yet to put your comments together. Of course, happy to discuss this further with anybody that'd like to give us a ring, and we hope that otherwise things are going well for you. Thanks very much.
Thank you.